My name's Kirk Forbush, and I'm the regional engineer down in Richfield, and we manage the Sevier River drainage and the Fremont River drainage. What I was going to do today is talk about the history of water rights and some of the water right basics. So, where the idea of water rights originated, what we have is riparian law and prior appropriation doctrine. Riparian doctrine is a system for allocating water in the eastern United States, which gives owners of land the right to use a reasonable amount of water as it goes through their property. The eastern states, all those east of Texas except Mississippi, follow the riparian doctrine, which permits anyone whose land has frontage on a body of water to use water from it. These states were the first settled by Europeans and therefore most influenced by English law and have the most available water. And back east, it rains a lot more, and so that's why the riparian doctrine is followed back there. Prior appropriation doctrine is a system for allocating water uses in most western states. First in time, first in right. And that means the first person to take a quantity of water and put it to beneficial use has a higher priority than the next guy that diverts water and uses it. The origin of the doctrine of prior appropriation. The development of laws governing water rights in the western United States was markedly different than in the East. The most important reason for this was the difference in climate and geography. In the East, precipitation is relatively abundant, water courses are numerous, and generally close to areas where water is needed. In most of the West, the opposite is true. Relatively slight precipitation means fewer water courses, and this increases the necessity to divert water to areas of use. The doctrine of prior appropriation, which is currently used as the fundamental of the water rights system in every western state, is developed to respond to that condition. Okay, the historic appropriators, who came first? Well, the Native Americans were the first appropriators. Community ditches dug by American Indians were used to divert and appropriate water in arid Southwest. The religious and military outposts of the Spaniards also required a stable supply of water. They sometimes used the canals of Native Americans and sometimes dug their own ditches. Thus, the Spanish and Mexican settlers who established missions, agricultural pueblos, and military posts were also early appropriators. Among the later Anglo settlers of the West, Mormons have been identified as earlier appropriators of water. They began using water upon arrival, and they would use the water for irrigation of crops, and consumption was diverted. Precipitation alone wasn't always enough to take care of their crops. Back in that day, there was no governmental laws. They had to make decisions to fit their environment and, as equitably as possible, create a system to supply water to the users. It was evident that the West was a desert, and from their decisions, the prior appropriation doctrine evolved and replaced the riparian water law. During the same period that the Mormons were settling the Great Basin, gold was discovered in California. Mining, particularly of placer claims, required the diversion of large amounts of water from rivers and streams, and the miners applied the tenet of mining law to water use. So the basic principles of mining law, the concepts of prior appropriation of water, which was developed in California, the California mining camps spread to the western states. As mineral discoveries led California miners to other states, a basic principle of mining law was that the miner who initially staked a claim, who was first in time, is protected in the development of the claim against other miners, and so his was first in right. This practice carried over to the use of water and became not only recognized as tradition, but also protected it in courts of law. Congress took a fundamental step in determining in deference to state and territorial water laws with the passage of the Mining Act of 1866. Under this law, Congress confirmed water rights for mining, agriculture, and other uses that had been acquired by private parties on public lands under local custom laws and court decrees. The result obtained even though many appropriators were trespassers on federal land. The first appropriative water right statute was passed in California in 1872. It allowed for creation of such rights by posting at the point of diversion the document stating the intended amount of right and its purpose of use. Filing for the right in the county recorder's office where the right was located and taking the steps necessary to perfect the right. In other words, put the water to beneficial use with due diligence. One example of that in our area was back before the Cox Decree. The Delta Canal companies decided they needed a reservoir. So what they did is they went and pounded a post there at the Yuba Dam and stated that they were going to build a reservoir there and stated the amount of water that that reservoir would hold. And so what they called that was the Hawley filing. And so that's just an example of how that began. In the Desert Land Act of 1877, Congress declared that the right to use water in the western United States by claimants under the act must depend upon bona fide prior appropriation. The U.S. Supreme Court held that the effect of the Desert Land Act was to sever title of the water from the public land. Congress directed that rights to use water be established under the state and territory laws separately from land ownership claims. And so the Desert Land Act was an important part of the history of water rights. Statutes giving state agency a major role. State governments began to realize that a central administrative system to control appropriative water rights, as well as a centralized office of record keeping for such rights, would be preferred to the haphazard administration which had occurred under the early statutes. Therefore, water rights law is most often regulated at a state level rather than a local or federal level. Wyoming was among the first states to enact statutes giving a state agency a major role in administrating appropriative water rights. The key feature of the Wyoming system were the requirement that an application must be filed by an individual with a state entity before a right could be created. Number two would be the necessary of a ruling on an appropriation by the state agency, including denying or approving a permit and denying it if there wasn't any water there to available to develop. And the third would be maintenance of a central bank of public records containing applications which had been made. And so this was kind of evolving as to where we are now with the state engineer's office, where there's a record and some order. Utah's state statute was enacted in 1903, so that's when Utah first started their water law as far as prior appropriation. Okay, in some ways, the traditional appropriation doctrine incorporated public values. The fundamental tenure of prior appropriation law was the land and water estates were separate, and that water could be removed from its natural location and used beneficially elsewhere. This facilitated the public purpose of making an inhabitable region out of an arid land. Also, there were preferred uses under traditional appropriative laws, which embodied a public settlement that domestic, municipal, and agriculture needs should be met before water could be put to other uses. And so the prior appropriation doctrine came around. As enacted in the state of Utah, contains some key points. First, water must be diverted and put to beneficial use. Second, to uphold the principle of first in time, first in right, all water rights have a priority date associated with it. And as we get into the management values of the different basins, priority date will become a major role in distributing water. And third, a water right can be lost by either abandonment or forfeiture. Abandonment is determined by the intent of the water user and does not require a statutory time period. A water right is lost by forfeiture if the right is not used for the last 7 years. And so the state engineer, want to make clear, doesn't go out and look for water rights that have been lost by non-use. It's basically somebody challenges a water right, it can be taken to court, and then the court decides and makes a decree that that water's been forfeited. This chart shows water distribution by priority date. You got the flow on the left side versus the time. And what you've got there is like a 1873 priority line and a 1922 priority line, and then a late priority, 1949. And as you look at that, you can see that as the flow rate goes, the earliest priority right has the right to divert and use the water for a longer period of time than the later priority dates. The high water or the latest priority date, the 1949, shows that the only time they can even divert water under that water right is when you're at flood state, basically. So priority dates are very, very important in distributing the water and making sure people get what they've got coming. Okay, from the past to now, division of water rights. Okay, this is the state engineer, couple of state engineers. The first state engineer was Willard Young, and the initial duties of the state engineer were to aid in planning, designing, and construction of water storage and conveyance facilities. And then the other state engineer, which is our state engineer today, is Kent Jones, which you met just a little while ago. And the jobs have dramatically changed from then till now. And so he basically explained what we do now too, as far as the state agency. Keep people from trying to kill each other over water is basically what it is. So this is an organizational chart, and the state engineer's our boss, and And then under him, we have the deputy state engineer, which is Boyd Clayton. And we have assistant state engineers under distribution, technical services, appropriation, dam safety, and adjudication. And then under the deputy state engineer, we have 7 regional offices. And so we have one in Logan, Vernal, Price, Cedar, Richfield, and a couple out of Salt Lake, Utah Lake, and in the Jordan River, and in the Park City West Desert. This is basically to show you how the different regions are laid out in the state of Utah. Whatever your individual focus on water rights might be, there's one point that should be clearly understood, and actions of water rights do not make more water. Water rights only establish who gets to use the available water that is out there. And so in our areas, you can see these different water right numbers, like they're a 2-digit number. In my region, they're the 61 areas. You got 61, 63, 65, 66, 68. And what they basically represent is basically little geographic boundaries, little sub basins for water. We also have in our region the 95 area, which is the Fremont River, which is over in Wayne County and Garfield. And so with that, the water rights, that gives it a water right number, like a 65-235 or something like that. And then after that, the water rights more defined by, if it's an application number, it has a large A before it. If it's a change application, it has a small a before a group of numbers. If it's a diligence claim claiming surface water prior to 1903, it has a large D. If it's an underground water claim, which is prior to 1935, it has a U before the number. If it's a fixed time application, it has a capital F. If it's a temporary appropriation, it has a capital T. And if it's a temporary change application, it has a small t. Okay, now we get to statutes and other definitions of the water right basics. Okay, the beginning of water rights, 1903, legislature passed water laws that required new uses of water be obtained by filing an application to appropriate. File that with the state engineer. However, it was unclear if the law applied only to surface water, and in some instances water was considered to belong to property owners. Surface water uses in place prior to 1903 were recognized as valid and are referred to as diligence claims. In 1936, because there was that question about the underground water, the 1903 law was amended to include all waters of the state as subject to appropriation statutes. So rights from wells were also recognized as valid and were referred to as underground water claims. And so rights to use water are not obtained simply because water exists on the property or beneath the property, because such rights defined like that would be called would be riparian and not recognized under Utah water law. Okay, Title 73 is where the legal framework for Utah water law is. That's where the basic and fundamental code is for Utah water law. All waters in the state, whether above or underground, are hereby declared to be property of the public. It's under Utah Code 7311. Beneficial use shall be the measure and limit of all water rights to the use of waters in the state, and that's under Utah Code 7313. Okay, then we start talking about what are the elements of a water right. Okay, as this graph shows, there needs to be an owner. There needs to be a priority date. Quantity of water would be listed, and it can either be in flow rate or volume or both. Flow rate is in like cubic feet per second, and volume would be in acre foot per year. Some water rights have storage, some don't, so that's just an element that would be included. Points of diversion need to be described so that everyone knows where the right is that they can start diverting water for the beneficial use. The uses, which could be irrigation, domestic, stock watering, mining, municipal, etc. The amount of use would indicate, like it's an irrigation right, it would tell you how many acres, or if it's domestic, how many families. Stock watering would tell you how many equivalent livestock units, which would say how many cattle or horses, whatever. And period use would show when the water can be diverted and used. Irrigation is normally, well, it depends on what part of the state you're in, but like on the Sevier River, it's usually April 1st to October 31st. And of course, domestics year-round, and stock watering most of the time is year-round. Place of use describes like the 40-acre tract in the section township and range as to where the water can be put to use. And so those are kind of a summary of the elements of a water right. And so what is a water right? Okay, again, this is extremely important. Beneficial use is a measure and limit of all water rights. So when buying a water right, you need to make certain that you're bargaining for a suitable right. And like we said before, all water rights have a point of diversion, source of supply, nature of use, and you can look at the kind of water rights and then determine what the diversion depletion rate is for the particular uses that particular water right has. That's important when you're looking to buy a water right to change. And the priority of the water right is important, so you know whether you only get it during flood stages or whether you get it whenever the water's available in most of the season. And then look at the ownership. Okay, the surface right is probably a decreed right with the priority of 1903 or earlier. And most of the surface water rights were fully appropriated by 1903. A well or other groundwater right is probably filed after 35, but could be an underground water claim that would be prior to 35. And springs are often sources of supply for diligence claims. And they are often used filing for stock watering uses. And to continue with water right details, of course they have priority, and in decrees, surface water rights are distributed based on priority. So that's very important to know what you're getting. And on the ownership, it's important to always check the ownership and don't just look at what our website says, because there may be some things like trust deeds out there that haven't been, that you may not know of or whatever. And so if there's a trust deed and the guy that signed the trust deed is still selling the water rights, he's selling something that he basically doesn't have. And so I've seen instances where that can create quite a mess. Okay, beneficial use, the measure and limit of every water right. The purpose of which water diverted under a water right is applied. And examples are in irrigation, stock watering, domestic, commercial, industrial, municipal. And a lot of these industrial, or like the power plant outfits, they required change applications to provide water for them. And in my area, over by Delta, there was the IPP project, and there was a Central Utah Canal water right that was used big time under that change. That was the underlying water right, and most of that water right was sold to IPP so they could drill wells and have water for the power plant. That canal basically doesn't exist anymore because all the water right was moved out and changed to a different use. So that's just one example of a change application. Okay, also water right flow and volume. Flow is measured in cubic feet per second, which is 1 second foot is like 449 gallons a minute, if gallons per minute is an easier thing to think about. Volume is measured in acre feet. And as the chart shows, it's basically an acre of land 1 foot deep in water is what an acre foot amounts to. And so this map of Utah shows the various irrigation duties in the different parts of the state. And duty is an estimate of the amount of water reasonably required for specific purposes such as irrigation or domestic use. For irrigation, what we generally use for a duty is what an acre of beef alfalfa would take per year to continue to grow, the number of crops you would get out of that. Duty of common uses. Domestic, we use like 45/100ths of an acre foot per family. And if it's like a part-time residence, similar to a cabin, we use a 1/4 acre foot per year for part-time use. Stock watering is 0.028 acre foot per animal unit, which is like a horse or a cow. That's like 25 gallons per day. And like the last chart showed, irrigation ranges from like 3 to 6 acre foot per acre, depending on what part of the state of Utah you're in. Okay, diversion versus depletion. Either amount can limit a water right. Even for municipal uses on change applications, both the diversion and depletion amounts for the rights being changed are considered in approval of the change application. Just an example of a change application. If you were going to change an irrigation water right, like for 10 acres of irrigation to stock watering, if you're in an area where the duty is 3 acre foot per acre and your flow rate can make that, then the underlying water right would be evaluated as a diversion of 30 acre feet, like 3 times 10. And the depletion of that for flood irrigation would be around 50%. So you'd have 15 acre feet because that's how much water would be depleted for irrigation use. On the other hand, the water right was being changed to stock watering, which is considered 100% depleted. And so the underlying water right, which was irrigation, changed to stock watering would give you like 15 acre foot that could be used for stock watering, because the depletion needs to, the heretofore and hereafter depletion needs to be the same. Okay, researching the records. We have where can you research our records? We have a great website, and it's very user-friendly. And on it, there's a lot of different ways you can look up the information that you want. If you know the water right, you can look up the number, and then you can go to the scanned documents and you can scan everything that's on that file and try to get all of the information that you're looking for. Or you can, our hard copies of these files are located in our Salt Lake office here, and people are welcome to come here and review these hard copy files in our office. And so that's kind of the two places you can, research these water right records. And if you're, we've always got our offices. If you're doing water rights in our regional offices, our offices are out there to help you. So if you need help down the road, you can always call and ask for help on any questions that you might have. With that, that kind of wraps her up for my presentation. Does anyone have a question? Yeah.
You didn't cover much on this division and depletion as far as information. I need a little bit more information on division and depletion.
Diversion, depletion?
Yeah, diversion and depletion. I didn't understand, like, if you're changing water from irrigation or, say, to municipal use, there must be some formula as to how much that, because some of the water would be used all the time in municipal use. In the case of irrigation, it might only be used 6 months of the year.
Right. We look at the underlying...
Is that going to be covered under the test, or we just kind of understand that there is a difference there?
Just understand there's a difference.
Okay.
Each change application is looked on an individual matter. And so the state engineer's office will look at the underlying water right and water records we have available to give us an understanding of what the historic diversion depletions have been. And then we look at whatever the water right is being changed to, so that we don't create an enlargement of the water right in the end when the change application is granted. So. Okay, is there anything else? Yeah.
When a user undertakes a project that increases the efficiency of a distribution system or irrigation or whatnot, is there any change in their water right to account for that increase in efficiency? Say a canal company is going into a pipe, and their existing system efficiency is low, resulting in a lot of water leaking through and actually providing water to downstream users. If they go to a more efficient system, that water may not be available to downstream users anymore. So does the Division of Water Rights consider that as they're reviewing those kinds of projects?
Yeah, we do. We look at if the place is covered under the underlying water right. If they're changing it, there needs to be, if they're changing from here to there, the here needs to go away if they're increasing their acreage over here, so that the balance does not increase. The water balance doesn't increase, or budget doesn't increase. In other words, if a guy goes with a sprinkler system is more efficient, that doesn't mean that he can increase the number of acres he irrigates. And a lot of times on the Severe River system, these canal companies have more decreed acres than the normal water year can provide water for. Sometimes in those cases, they can increase their efficiencies and cover more of their decreed acreage, which is fine under the water law. But if somebody out here that has a water right for 5 acres and that's it, but he increases his efficiency to where he might could do 10, that would be an enlargement of the water right if he tried that. So that's not allowed. That answer your question?
Yes.
Okay.
We have a question from St. George. On the state database, can existing water well / or test well data be found there on the database?
Yes, it can. Yeah, we have a good website that all of that information is available. There's, if we go to the GIS maps, there's a application there that you can look up and have point of diversion show up on the map so that you can look at an area that you're concerned about and see whatever's there. And if a water right number pops up on that point, you can click it and get all the details of the water right. Yeah.
Hi, is there a conversion factor between acre feet and CFS? So, because I know some rights only show CFS.
Yeah, you can convert, you know, one CFS flowing continuously will basically create 1.983 acre foot per day. You know, so you can convert the flow rate to see how many acre feet it will make in the period of use that you have. And so, yeah, that's the conversion factor.
On page 9, when you there's this chart about duty, the estimate of water needed for a specific area, are there requirements on duty? Is it regional? So if you have, say, 100 acres and 1 share of water, you don't have enough water to water that even though you wanted to try to do it?
Yeah, the duty is whatever it is. And like on that GIS map, there's a app on that also that you can see what the duty is for the particular area that you're interested in. But like if like you've got this acreage out there and the duty is whatever it is, if you have the water to apply it to that acreage, then that's fine. But if you don't, just because the duty is that doesn't mean that you can find other water from some other source to make up the difference. Okay, looks like I've answered every question that anybody has. So, okay.